Hello, my name is David Scher, and I'm an attorney with the Employment Law Group. Today I'd like to talk about data privacy and data security, especially in the employment context. Eric Schmidt, the CEO of Google, said that the amount of data being put out by human beings in the world every 2 days is the same amount of data that has been put out in human history, going back to the beginning of recorded history all the way into the year 2003. In other words, every 2 days, the amount of data that's coming out into the world is the same as thousands of years of data in prior history before there was advanced computing technologies. And that really has changed the world. On Facebook, there are 2.5 billion posts per day. There are about 3,000 tweets happening on Twitter every second. During the presidential debate, there were 105,000 tweets per second. Really extraordinary amount of information that is coming out there. Not to mention the innumerable social websites and the ability of websites like Spokeo and other related websites to find out just about anything on anyone, even on Google Earth, looking at, for example, somebody's house. What does this all mean in the employment context? It's very important for employers to carefully understand what information is coming in and what information they need to know about. We recommend that an employer have a very clear yet reasonable social media policy. It's simply a reality that employers are going to use Facebook and other social media at work. They may do so on their private phones, for example. So a social media policy should advise employees that information that they obtain while using company computers is company information and could be surveyed or used in any context, including an investigation, so that employers are on notice that if they're using the computer for personal reasons of any kind, that information could actually be obtained, even if it's so fleeting as a text. Furthermore, we recommend that employers conduct thorough background searches to include social media, perhaps even hiring a third-party investigator to understand what is out there, what the employee is doing, so that the employer can be educated before they hire an employee and make an educated decision based on legitimate legal reasons for hiring or not hiring the employee. Now, if you're an employee, what should you do? First of all, generally you shouldn't be posting about your employer on social media. Now, it is lawful to engage in what is called concerted activity. That means it is lawful to post on social media gripes or concerns about an employer if you think you're gathering or organizing a response, like a union type of response. And it may even be lawful to disclose illegal conduct that your employer is engaging in, if you're doing so for the purposes of trying to notify management and correct the problem. But even though it may be legitimate, it's still really not the best idea. It certainly doesn't engender good relationships with your employer, and it really isn't the best way to disclose illegal conduct to your employer. The better course of action is not to gossip about or talk about your employer in social media, but instead to prepare clear written instructions and written information directly to your employer, to your manager, to the Human Resources Department, and to the Compliance Department. This will provide you the best protection against retaliation and will ensure that your disclosure can be protected under the law. If you have questions about this, the Employment Law Group can handle these types of issues and does so all the time. You can reach us at www.employmentlawgroup.com. Thanks and have a really fantastic day.